Welcome to the deep dive. Today, we're diving into something, well, deeply human. A paradox, really. The prenuptial agreement.
Ah, yes, the prenup.
Exactly. You've got two people, totally head over heels, right? Planning everything together. And then suddenly, bam, they have to think about divorce.
That cold, hard logic crashing into the romance.
It really is a clash, isn't it? Soaring feelings versus stark practical reason.
It kind of reminds you of some observations about online dating. David Brooks wrote about this.
Oh, right. How those platforms are all about rational selection. Listing traits, comparing.
Exactly, pure calculation. But Brooks argues, well, it often doesn't lead to lasting love.
Because real love needs that. What did he call it? An enchantment leap.
That's the one. Moving beyond just ticking boxes to something, well, more profound, poetic even.
So we're going to take that tension, that dynamic, and apply it to something huge. The law.
Yeah.
Our mission today is to unpack how deeply law is woven into, well, the fabric of society, often in ways that really challenge our assumptions.
Assumptions like law being universal or fixed.
Precisely. We'll explore theories showing law isn't static at all. It's dynamic. It reflects and shapes the societies it exists within.
And it's quite a journey we'll take you on. We'll start with some early ideas, like how law gets rationalized. Then trace how legal systems evolve with societal changes. We'll look at economic forces, power dynamics, how they shape legal control.
And even the legal profession itself.
Absolutely. How it mirrors society's own complexities. It's all about challenging that myth of law as this transcendent, unchanging thing.
All right, let's jump in. Max Weber, a giant in social thought.
A foundational figure, for sure.
He argued that modern capitalist societies are basically defined by the triumph of rationality.
Right. Calculation, efficiency.
And it's not just business, is it? He saw it permeating everything, pushing aside tradition, religion, pure emotion.
That prenup dilemma you mentioned.
Pure Weber, right. The rational contract versus the emotional bond.
Exactly. And for Weber, as society gets more rational, law does too. Modern law runs on logic, calculation, not oracles or old customs.
And he had that intriguing idea about law becoming autonomous. What did he mean by that exactly?
Basically that it becomes functionally insulated or separate from other institutions like religion or politics. It develops its own internal logic.
Okay. So how did this rationalization happen according to Weber?
Well, he talked about this elective affinity. Think of it as a strong, almost chosen connection between Calvinism, the rise of capitalism, and this rational mindset.
Calvinism, how does that fit in?
The core belief was predestination. You were either saved or damned, and you couldn't change it. This created, as you can imagine, huge anxiety.
Right. So how do you cope?
People started looking for signs. They were among the chosen. This led to intense hard work, accumulating wealth but living frugally, behaviors that perfectly fueled early capitalism.
And fostered that calculating, rational approach to life.
Precisely. And this broader societal shift towards rationality, in turn, rationalized the legal system itself.
But hang on, isn't law supposed to be universal? Something fundamentally right, applying everywhere?
The natural law perspective.
Yeah, tracing back to Plato, Aristotle, Aquinas. The idea that law should reflect some universal morality, a divine order.
Aristotle's famous quote, right? He who bids the law rule may be deemed to bid God and reason.
It's a powerful idea, but it struggles to explain shit. Well, all the differences, doesn't it?
Huge differences across history and cultures. If Western law is natural, or all others just arbitrary, it gets problematic fast.
So this is where the sociolegal scholars come in.
Exactly. They see legal systems not as divine, but as fundamentally human products.
Deeply intertwined with the societies they're part of.
And evolving in stages right alongside those societies. It helps us see law as this dynamic thing, changing with human civilization.
Okay, let's look at another key idea. Henry Maine, 19th century. His concept of moving from status to contract.
Right, a very influential idea.
He saw ancient societies dealing with people based on their birth status, their inherited position, like feudal lords and serfs.
Your legal standing was fixed by who you were born as.
But modern societies, Maine argued, focused on the individual, leading to laws about individual rights, obligations, and crucially, free agreements. Contracts.
He saw this as the defining feature of modern progressive civilization.
But his view had some issues, didn't it?
It did. Critics point out he was a bit of an armchair scholar, maybe factually off on some points, and perhaps a bit naive.
Naive how?
About modern law being totally free of status biases. He was maybe too optimistic.
And we see evidence challenging that optimism today, right?
And absolutely. Look at the examples from our sources. Kids, as young as 6, mostly African-American, arrested for classroom stuff. 12-year-olds for shoving.
While at the other end, you have employers causing injuries or Wall Street folks triggering crises, often facing much less severe consequences.
It starkly shows that status, or something very much like it, still matters.
Mm.
Deeply, even in our supposedly contract-based system.
Okay, let's shift to another major figure, Émile Durkheim. He looked at social bonds, solidarity, and law.
Right. Durkheim connected the type of social solidarity to the type of law.
He talked about mechanical solidarity in pre-modern times, homogeneous societies, strong shared morals, what he called the collective conscience.
And when someone violated those deep-seated morals,
Intense shock, outrage, leading to repressive law, punishment for punishment's sake, often public, to reinforce those shared values. Think public hangings.
okay, and the contrast.
Organic solidarity in modern societies. Complex, diverse, lots of division of labor, making us interdependent.
Like a complex organism, all parts relying on each other.
Exactly. And here, law becomes restitutive. The focus shifts.
Less moral outrage, more about fixing the disruption.
Right. Restoring the balance. Think tax evasion. Often it's about paying back the money, maybe a fine. It's less about moral condemnation, more about systemic equilibrium.
But Durkheim still believed every society is a moral society, indeed, even modern ones.
He'd point to cases where modern society does show collective moral outrage. Remember the Octomom, Nadia Suleiman?
Vaguely, yeah. Lots of kids at once.
14 via IVF, adding to 6 she already had. Single, unemployed, on assistance. Initial fascination turned quickly to outrage once the details emerged.
People felt it was morally wrong.
Totally. There were parody songs, calls for sanctions against her doctor, demands for regulation. It showed a kind of moral union, even in our diverse society.
But how stable is that consensus? That's the tricky part.
Exactly. Look at the culture wars. Issues like same-sex marriage, Prop 8 in California, then the rapid shift in public opinion and law. It reveals deep moral divides, doesn't it?
It certainly challenges Durkheim's idea of a unified moral consensus in contemporary society.
And there's a further wrinkle with Durkheim's theory, a factual one.
Yeah, a bit of a fatal flaw, though his core insight endures. Anthropological evidence often suggests pre-modern societies actually used a lot of restitutive law.
And modern societies often rely heavily on repressive sanctions, prisons, long sentences.
It's kind of the opposite of his proposed sequence. But still, the fundamental idea holds. The form of law generally aligns with the form of society.
Okay, so society's structure shapes law. What about economics and power? That feels crucial.
Hugely important. Many scholars argue economics is paramount, that essentially capitalist law looks, smells, and acts capitalist.
How so?
Well, civil law provides the whole infrastructure, right? Contracts, investments, property rights, even defining the nuclear family in ways that support the system.
And criminal law?
Protects private property think theft. But it also subtly normalizes the coercion inherent in capitalism.
How does it normalize coercion? Jeffrey Ryman talked about this, drawing on Marx.
Right. Ryman argues the very line between criminal and non-criminal is baked into the capitalist structure.
Give me an example.
Okay, think about dangerous workplace conditions or massive industrial pollution. These often aren't treated with the same criminal severity as, say, street robbery.
Why not?
Because capitalist law tends to frame labor conditions as contractual. The risk is seen as something the worker assumed when they took the job, not as direct coercion or violence by the employer.
Wow. Ryman used an analogy, didn't he?
About
Oxygen.
Yeah, a stark one. Imagine a society where a few people own all the oxygen. Everyone else has to work for these oxygen owners just to breathe.
Even without chains or whips.
They're effectively slaves. He argues this mirrors the hidden coercion within capitalist labor contracts. It's structural.
So law doesn't just reflect the economic system, it actively shapes it.
Absolutely. History shows this clearly. Tiger and Levy traced how feudal law was dismantled and replaced by capitalist law over centuries.
And lawyers played a key role.
A crucial one. Allied with merchants and monarchs, they pushed the ideology of free contract, breaking down old hereditary bonds.
Is there a modern parallel?
You could argue there is. Think about the rise of unfettered finance capitalism. Alliances between politicians, lobbyists, lawyers.
Like the repeal of the Glass-Steagall Act, the 1933 Banking Act.
Exactly. Repealed in 1999, removing limits on bank risk-taking. This paved the way for complex instruments like credit derivatives, a massive market.
Which contributed to the 2008 financial crisis.
Right. The core insight is that powerful groups use resources including legal changes, to advance their preferred economic system.
We see specific examples of this link, too.
We do. James Willard Hurst studied the Wisconsin lumber industry. He found law was seen and used as an important economic asset.
Designed to boost private production.
Yep. And Amanda Perry Casares, looking at Bengaluru, India's Silicon Valley, saw something similar. Law builds trust, sure, but economic interests, especially attracting foreign investment,
tend to win out over civil society concerns.
increasingly so. She quotes an Indian finance minister essentially saying debate is fine as long as it doesn't hinder 8% growth. Legal frameworks often bend to economic priorities.
There are even more stark materialist analyses, aren't there? William Chambliss on vagrancy law.
A classic. England, 1349, right after the Black Death killed maybe half the population. Huge labor shortage, wages soaring.
So the law stepped in.
Big time. It made refusing work illegal, capped wages, even banned giving charity to able-bodied beggars. Economic needs completely overrode even religious principles.
Wow. And Ruscha and Kirchheimer looked at punishment itself through an economic lens.
They did. They argued punishment methods, branding, hanging, prisons depend on the economic system and its need for labor.
So feudal lords wouldn't execute serfs.
Because they were valuable assets. They preferred physical punishment. Later, mercantilism needed labor, so you get indentured servitude.
And the Industrial Revolution, surplus labor.
Exactly. Leads to prisons, but prisons designed to be harsh torture like treadmills, so they wouldn't seem appealing compared to starving outside.
So for these thinkers, law is fundamentally tailored to the needs of the production system.
Yeah. Ensuring a workforce, setting rules, providing infrastructure, managing disorder, all serving the dominant economic mode.
Okay, let's shift gears slightly. Michel Foucault offers a different angle on power and control.
Right. Foucault saw power not just in economic structures, but as more decentralized, embedded in discourse, in social practices.
He famously traced that shift from gory public executions
To regimented, almost clinical prisons, just a century later.
And for him, this wasn't just about being more humane.
Not at all. It signaled modernity's obsession with predictability, rationality, and crucially, getting individuals to discipline themselves. Internalize control.
Which brings us to panopticism.
Inspired by Bentham's theoretical prison design, the panopticon. A circular prison where a guard could see any inmate at any time, but the inmates never knew if they were being watched.
Just the possibility of surveillance
Is enough to produce conformity. You internalize the discipline because you might be watched. It's a powerful metaphor for modern society.
There's that article, The Undercover Parent.
A perfect modern example.
Yeah.
Parents telling kids they might install spyware in their computers. The uncertainty leads to self-regulation. Disciplinary surveillance replaces direct punishment.
David Garland built on Foucault with his culture of control.
He did, noting something interesting. A rise in overtly punitive responses in the US and UK since the late 20th century. Almost anti-modern in a way.
What drove that, according to Garland?
The anxieties of what he calls late modernity. Rising crime from the 60s, suburbanization, fragmenting families, economic insecurity, dismantling welfare, all creating chronic insecurity.
Intensified after 9/11.
Massively. Which helps explain the explosion in government surveillance wiretapping, email interception revealed by Snowden, and the relative lack of public pushback shows how deep that anxiety runs.
This culture of control also fuels mass incarceration.
Absolutely. Those get-tough policies starting in the late 70s. Prisons viewed almost as quarantine zones for dangerous people.
And the surveillance isn't neutral, is it?
Far from it. Sean Heyer's work on CCTV in Canada showed it disproportionately targets suspicion onto racial minorities, the poor, the homeless, reinforcing existing biases.
This control culture goes beyond prisons, affecting everyday law enforcement, too.
Definitely. Look at Isa Kohler-Helsman's study on mass misdemeanors in New York City.
Misdemeanors arrests skyrocketed way past felonies,
Double between 1993 and 2010. But conviction rates were often low.
suggesting it wasn't purely about punishment.
Her argument is it's about managing people through engagement with the criminal justice system, using arrests and court appearances as a form of social control.
And again, disparities were huge.
Stark. White misdemeanor arrests went up 35%, but for Black and Hispanic individuals, it was 105% and 158% respectively. It effectively marks violators for future targeting.
Which leads straight into the criminalization of poverty.
Exactly. Beckett and Herbert's study, Banished in Seattle, tracked this. Anti-loitering laws, youth curfews, park exclusions.
Officially about social disorder, the broken windows idea.
But they emerged right alongside rising urban poverty, homelessness, and gentrification. The result? Criminalizing the state of being poor.
Ferguson, Missouri is another stark example.
Unbelievable numbers. 25,000 arrest warrants in a town of 21,000 people. Mostly for poverty violations, driving without insurance, minor stuff.
Which then escalates.
Fines pile up, leading to warrants, suspended licenses, jail time, making it impossible to get jobs or housing. It's a modern debtor's prison, and it's widespread.
Jonathan Simon called this governing through crime.
Yeah, where even non-criminal social institutions start using the logic and language of crime control, shifting from support and distribution to danger containment, and the poor bear the brunt.
You can almost feel the public's punitive impulse in some of this.
Oh, absolutely.
Yeah.
Just look at online comment sections about crime. Visceral anger, calls for zero tolerance, harsh sentences, the death penalty, phrases like waste taxpayer dollars supporting this garbage.
And it can be disturbingly broad, that stupid criminals blog example.
Right. Readers not only wanted the murder suspect to fry, but they turned on the victim too. Why was she homeless, looking for kind strangers to take advantage of?
It shows a cultural field just saturated with anxiety, hostility towards taxes, anger at perceived blights, sometimes missing basic empathy, even for victims.
A really complex and often troubling picture.
So after exploring all these connections, structure, economics, culture, is law always a perfect reflection, a mirror of society?
Well, Brian Tamanaha pushes back on that simple mirror paradigm.
How so? His Micronesia example.
Exactly. He looked at the attempt to transplant U.S. law onto the Yap Islands. Their existing caste system clashed fundamentally with anti-discrimination laws.
Their whole culture was different.
Right. Consensual decision-making versus an adversarial legal model. Community-based responses versus a state monopoly on force. It just didn't fit. The law was completely out of sync.
So law can be detached from society.
It can. Tamanaha makes a strong case against a simplistic mirror view. That said, for many broad patterns, the idea that law and society generally reflect each other, the reigning mirror paradigm, still holds a lot of weight.
This actually brings us back to a surprisingly tricky question. What is law, really? How do we define it?
It seems obvious, but it's not. Most people assume, written rules, police, courts, the state.
But that's a very Western state-centric view.
Totally. By that definition, many societies throughout history would have had no law.
Malinowski's work on the Trobriand Islanders.
A classic counterexample. A preliterate society, no formal courts or police. But they had intricate systems of rights, obligations, informal rules that were absolutely binding.
We even have examples closer to home, don't we? Like tipping.
Perfect example. Not written down in statutes anywhere.
Yeah.
But try not tipping in the U.S. It's a powerful social norm, almost like law. You mentioned your Italian guests got chased down.
They did. They were baffled.
Richard Schwartz's study of Israeli communities also highlights this. The kfutza versus the moshav.
Remind us.
The kfutza was a highly communal socialist settlement. Intense interaction. Public opinion, gossip, even just tone of voice were enough to maintain order. No need for formal law.
But the moshav.
More private, less communal farms. Informal controls were weak. Schwartz said trying to scold someone would just get you laughed at. So formal legal institutions merged there.
And interestingly, once formal law appears,
it can actually weaken or atrophy those informal controls. They become less necessary or less effective.
There was that modern twist to the Vermont Vandals.
Oh yeah, wanting their mugshots posted on Facebook. Zero fear of community shame. Maybe even wanting the notoriety. It suggests in some contexts today, informal controls really are laughable.
So defining law is complex. Is it all social control or just the formal stuff?
It's debatable. Using different terms, law, norms, mores gives us precision. But we have to see the functional similarities. Whether society relies on formal law or informal mechanisms depends entirely on its social context.
Which leads perfectly into how the legal profession itself mirrors society.
Absolutely. It's contoured to society, as Richard Abel and Philip Lewis put it. Legal practice looks very different across countries because of underlying socioeconomic forces.
What did it look like in the USA after World War II?
Highly stratified. You had solo practitioners, often from ethnic minorities, dealing with individual clients, low income, low security. That was Jerome Carlin's study. And the other end, Erwin Smeigel's Wall Street lawyers, mostly white Anglo-Saxon Protestant men serving big corporations, high income, high security.
A clear divide.
And later studies, like Heinz and Lohmann in Chicago, confirm this. The profession was bifurcated. split based on client-type individuals versus corporations. And status came from the prestige of your clients, directly mirroring broader societal inequalities.
But things have changed since then, right? Demographics.
Big changes. The number of lawyers roughly doubled between the late 60s and 2000s, and crucially, many more women, nearly half of law students now, and people from minority backgrounds entered.
So did that break down the stratification?
Paradoxically, no. Despite diversification, research suggests the profession actually became more stratified in some ways.
How? The glass ceiling.
Exactly. Women and minorities still face significant barriers: harassment, stereotyping, being passed over for partnership in big firms, earning less on average.
So the idea of the legal profession is too simple.
It really is. It's more accurate to talk about distinct legal professions whose internal structures, hierarchies, and inequalities often parallel those found in the wider society.
And this isn't just a U.S. phenomenon.
Not at all. It's global. Desolé and Garth studied transnational commercial arbitration, handling big international business disputes.
What did they find?
An elite group, almost a mafia as they called it, of lawyers appointing each other. It started informally, but became more rationalized, technocratic, mirroring the global economy itself, pure Weber again.
This international influence spreads.
Yes, you see the internationalization of legal practice and culture everywhere, from Asia to Latin America. Even legal education changes, with things like human rights or law and economics courses being introduced, sometimes timidly returned through the window.
And locally.
The same dynamics play out. Silicon Valley shapes its lawyers' partners dance to the tune of their clients. Even studies of divorce lawyers in places like Maine show how local economic conditions, professional norms, and personal values all interact to shape practice.
So the big takeaway is?
The legal profession, or professions, and the way law is practiced are both shaped by, and in turn, help to shape, the entire social, political, and economic landscape around them.
Wow, we've covered a lot of ground.
We really have peeled back the layers today. It becomes clear that law isn't some distant, fixed thing. It's alive, dynamic, deeply connected to our fears, our hopes, our money, our morals.
Absolutely. From Weber's rationality and Durkheim's solidarity, through the critiques of capitalist law by Riemann, Foucault's culture of control, all the way to the legal profession itself.
It all points to legal systems being profoundly human creations,
Mirroring and shaping the societies they serve, constantly evolving.
It's a much more complex and intertwined relationship than we often assume.
So maybe the next time you encounter a legal document or hear a news report about crime, or even just notice a strong social norm, pause for a second.
Ask yourself,
What kind of society does this law, this norm reflect? And maybe even more provocatively, what kind of society is this law trying to create?
that's definitely something to mull over.
Indeed. Until our next deep dive.